Ladies and gentlemen, today I'm going to speak about the vital role that arbitration plays in the development of rule of law. So, by rule of law in any process, any legal process, it means an idea to ensure that laws are applied equally to the person for whom law is to be applicable and in a fair manner. When you say fair manner, it means at least three elements. Like law should be equally applied, first, it's given. Second, the laws should be applied in a very independent and impartial manner. And the third is the parties should have the sufficient right of information on the matter. They should know. In other words, they should have like a timely access to the all relevant informations. So today we're going to discuss how these three elements in the arbitration process helps in the development of the rule of law. So just to set out the background of this presentation, I shall look into the three different aspects of rule of law, namely equality, impartiality, and transparency. And together I will discuss its interplay with the arbitration system. And while doing so, I will be referring to some provisions in the Hong Kong arbitration ordinance and HKIAC administered arbitration rules as a non-exhaustive examples. First, let's discuss about rule of law in general. In arbitration, it's actually the parties who actually define the rule of law that would be applicable to them in the dispute, in the situation of the dispute. So in a way, they first think that in the relation between them, there might be a disputes. In the agreement between them, there might be a disputes. And to resolve that disputes, they define the rule of law which would be applicable in those disputes for the resolutions of the disputes. Essentially, in arbitration, parties can choose at least two sets of rule of law to be applicable in the future disputes. First is a kind of substantive one, or like they can choose which law, substantive rule of law, or the governing law of the agreement. And the second is more of the procedural nature. For example, the very arbitration agreement or arbitration clauses. So these are two different sort of the rules. Also, that can be defined in a single piece of the agreement or a contract. Even the clauses would be taken as a separate arbitration agreement. So how HKIAC incorporates the relevant provisions in regard to this. For example, Article 36.1 of the HKIAC administrative regulations allows party to choose, for example, the English law is a substantive law to resolve the dispute, while simultaneously it can refer to the HKIAC administered rules as a procedural law by referring HKIAC or Hong Kong HKIAC as the seat of the arbitration. So they can also define the procedural rule of law just by reference to the seat. In addition to these, they can also tailor how the arbitration proceedings are to be carried out, and they can also have their say together with the tribunal about how they plan or time the proceedings. So in arbitration, in nutshell, they themselves define the rule of law to be applicable in the case of future disputes, and they simultaneously pledge to be legally bound by it. Now let's discuss into the components of the rule of law, and these three components that I have stated earlier, those components interplay in the arbitration process. So first, let's talk about the equality. At least for the arbitration process, equality does not mean equality like how Marxists would put it. It's not like equality of the subsistence or equality of the means, or equality in terms of hiring a better lawyer, or equality in terms of being able to pay for the effective legal representation. It's not like that. It means, first, equality of the choices in defining the rule of law, and secondly is the procedural equality. Let's first talk about the equality of the choices. SKIC administered rule, Article 36.1, as I referred earlier, allows the party to choose the rule of law for the substantive part, like the governing law and the procedural law. So it somehow like respect the party, and the parties are equal. The parties to the agreement are considered equal to choose and agree on what substantive law they wish to be bound by it, and also they are free to choose, or they are equal to choose the seat of the arbitration. So that's substantive equality, or equality of the choices. Now let's talk about the procedural equality. It's a very important consideration in any arbitration system. It essentially means that the parties should be given the reasonable opportunity to be heard, and also ensures that if the parties can demonstrate to the contrary, means they were not given a reasonable opportunity to be heard or present their case, then that should be a ground to set aside the arbitration award, or set aside the implementation of any interlocutory or interim measures. For example, let's take as an example, it would be more clear by example. Section 34.1 of the Hong Kong Arbitration Ordinance allows the party to make setting aside claim in case of he can demonstrate, in case the party can demonstrate that he or she was not given a fair opportunity to present the cases. And there are several high court cases in Hong Kong where error in the due process has been taken as a basis for setting aside of award or other arbitral award. The second important consideration is impartiality and independence. So another important aspects of any arbitration system, or any important or most requisite element in any workable and sustainable and popular and accepted, internationally accepted or locally accepted arbitration system is first an expectation, and second a proving that the arbitration process would be impartial and independent. For example, Hong Kong International Arbitration Center is a very reputed arbitration seat, and we can imagine if it could not have demonstrated that it is a impartial or independent venue, the parties worldwide would have a very less motivation to choose in the Hong Kong as an arbitration seat. And now let's take an example how the Hong Kong International Arbitration Center makes the provision to ensure the impartiality and independence within its internal rule or HKIAC administered rules. For example, Article 11 of the HKIAC administered rule provides several provisions, including nationality requirement, meaning that there is a party and there is an arbitrator, so the parties and the arbitrator could not be from the same nationality. There might be a bias owing due to the nationality. There are also provisions that require the nominated arbitrator to declare and sign off the conflict of interest. And for the impartiality, it also set a very not so high, optimal level of test for the party to make their case on whether they are confident or not in the impartiality of the arbitrator. So the test is not very high as per the Article 11 of the HKIAC administered rules. The rules allows a party to challenge the arbitrator by submitting reasons and evidence that give rise to a justifiable doubt. So not doubts, but justifiable doubts as to the arbitrator's impartiality or independence. So the parties are not required to put into the actual evidence of conflict of interest. But what is enough is just to go by justifiable doubts. So justifiable doubts is not objective metrics, it's a subjective metrics, and the relevant inquiry of this particular requirement on the part of the requirement that need to be satisfied and demonstrated by the attacking party is to be assessed on case-to-case basis. In addition, HKIAC Article 13.5 requires the tribunal secretary, which soldiers the administrative roles in the arbitration process, and it also requires this tribunal secretary also to be impartial. And let's talk about the third component, and that is transparency. So in arbitration process, the transparency aspect of the rule of law, it's very tricky. Transparency in common parlance, which means it's relevant to the public law domain, or resolutions of the public disputes, which is in public law, it means that the citizens have the right to know informations. They should be having access to information in the matter that their government is in matter that concerns them. And when it concerns them, it could be, for example, any matter that is not classified as a confidential matter and is in the possession of the government. But in the process of the arbitration, the transparency has a very limited applications, because it has to be balanced with the need to have the confidentiality in the overall arbitration process. So there's a bit of a contrast in between the traditional sense of transparency in the legal system and the transparency aspect within the arbitration system. So, as I stated earlier, transparency means the disclosure of the needed information, but also is arbitration is a private dispute and not a public dispute. It's a dispute essentially between the private parties, and usually and most of the time private parties themselves pay for the arbitrator and also shoulder the cost of the administrative cost of the arbitral proceedings, and there's no taxpayer money being used in the arbitration process. I think the limited transparency in the arbitration process is justified. So by limited transparency, it means that the stakeholders or the parties concerned have the right to obtain and be given access to all the concerned information in a very timely manner, and time is also of essence here, which is recognized in various provisions of, for example, the HKIAC administered rules. For example, all issues, claims, and the defense the party brings to the tribunal should be communicated to the other parties per Article 16 and 17 of the HKIAC administered rules. And it is important to understand that the HKIAC or any other arbitration system does not encourage a surprise attack, surprises during the course of the hearing. So the witness statement is communicated to the other parties before the other parties can cross-examine that witness. The statement of claim has to be communicated to the other parties, and on the basis of which the other parties are expected to submit their replies. So it does not encourage the surprising attacks or findings in any way. So we talk about like rule of law in general in the arbitration system, and the aspect of equality, the substantive equality or equality of the choices in defining the arbitration agreement, procedural equality, the aspect of impartiality and independence, and also limited transparency. And all these three together, these are the underlying component or expectations within the arbitration system. So and incorporating all these three elements, the arbitration system does help in the development of the rule of law. Thank you.